Welcome to Case by Case. This is a podcast brought to you by Luke and Calum Chain from ZFZ. How are you today, Calum?
I'm very good, Luke. We have a very ZFZ case to discuss today.
We do. This is right in our sweet spot, actually. We've got a US Rule B maritime attachment to talk about and how it relates to substantive English law. So, with our combined US English outfit, we're kind of, it's a great one to be looking at and examining closely.
Exactly. This is what we do. So I'm hoping we can have an interesting conversation on it.
Yeah, I think so. There's a few kind of hallmarks in this case that kind of resonated with me or reminded me of other cases we've handled recently.
Yeah, and it's one we see a lot, this Rule B in support of the London arbitration. So it's something we're familiar with. But there's some interesting points in this one too around how a very particular, reasonably common type of action under a charter party would be treated by a US court when deciding whether or not to go ahead with the Rule B.
Yeah, it's not just about Rule Bs, right? There's actually part of the Rule B action here, and one of the key issues for determination was whether there was a valid prima facie maritime claim for the purposes of Rule B jurisdiction. And the US courts will look to the law, the substantive law that's going to govern the actual dispute, the underlying dispute. Of course, Rule B being for security actions. And here that was English law. So we actually have to look at English law and the English substantive law to understand the nature of the underlying claim and then how that kind of plays into the jurisdictional issues in the US.
Exactly. And it's the two dovetail in quite an interesting way. Maybe helpful to just give a little bit of background to how this case arose and how it came to be before the US courts.
And before you do that, let me just get in there quick for our citation lovers out there who I know whenever they listen to one of our podcasts urgently jot down the citation. I just have these, I don't know how many people are out there doing it, probably absolutely none. But for good order, if you want to go and find the case, I think it always helps to have the citation in there. This is from the United States Court of Appeals for the Third Circuit, number 22-1276. It's a case involving Bunge as the appellant versus ADM and a bunch of other parties. But if you're looking for it, it's the Bunge versus ADM case, and it's an appeal from the District of Delaware. Okay, yeah, it was argued in January 2023, and the decision came down on June the 2nd, 2023. So relatively recent. We have Bibas, Nygaard, and Fuentes as the circuit judges who gave this decision.
Yeah, and this decision was in the context of the Rule B application. So this is the decision that we're talking about today was over in America. It's a security action that they're determining. However, it turns on these issues of English law, or at least it's influenced by these issues of English law. And the background to those English law disputes is obviously helpful to understand because it goes a long way to understanding the case. This is a charter party chain dispute. You have a head charter and a sub charter. The head charter is a time charter, and the sub charter is a voyage charter. The head charter is between Tongley Shipping and Bunge, and the subcharters between Bunge and ADM. There was a voyage to the Mississippi River that ended seemingly ended in chaos. There were issues with delay. There were issues with the berth owner arresting the ship for unpaid berth dues. It was one of those voyages where everything seems to go wrong, and as a result, the head owner eventually had to settle a dispute for a significant sum with the berth owner, and the head owner was then looking to pass that down the chain to Bunge.
And just pausing there, Callum, that it's a significant amount that was paid to the birth owner, $3.25 million. You don't see that every day, right? So there must have been some significant issues with this one.
Yeah, they parted with a lot of cash. There was also an arrest of the ship in there, so you imagine it was stuck for a long period of time. The ship lost 2 anchors while it was there. It was a catastrophe. From the paragraph summary that we have in this opinion, it was a real disaster. And Bunge then obviously looking to pass it on down the chain to ADM under the voyage charter. The way that Bunge were proceeding in this arbitration, it seemed to me, at least, Luke, I'm not sure whether you read between the lines differently, but it was very much that Bunge were looking to resolve the issue in the head reference first and then deal with it under the sub-reference rather than deal with both at the same time. That's probably because they were disjointed. If they were truly back-to-back, if there was a time charge party up the chain and a time charge party down the chain on back-to-back terms, then I would imagine Bunge would be running this case, concurrently. But as it was, it looked as though they were looking to deal with the head reference first, but they had put in these pleadings in the sub-reference to say, if we're found liable under the head reference, then we do want to pursue this arbitration against you, ADM.
Yeah, it was much more kind of contingent than you often see in these cases. Like sometimes when you're running the argument down the chain, and that's what we're talking about here, the Bunge facing down to ADM under the voyage charter is where most of this is playing out, albeit claiming for losses coming through from the head charter. Often you see the framing of that claim in a more direct way and less contingent. You almost don't need the language around, well, if we are liable in the head reference, then we are going to claim from you. You just claim it, and you do it on a non-reservation basis. It seems like it's a more direct kind of claim that's in that way.
I had exactly the same thought. And, often if you're in these back-to-back chains as the middle party, you end up in a position where you're arguing one thing up the chain and the opposite down the chain. But that's part and parcel of maritime arbitration. And, it's not the case that if you've argued something in the head reference, then that prejudices your position in the sub-reference to argue the total opposite. That's simply the nature of passing the claim up and down the chain when you have a claim and a counterclaim going either way. So I was slightly, I guess, in terms of approach there in the London arbitrations, you don't have enough information in the judgment really to understand why it was that Bunge had taken that approach. But I was slightly surprised to see it because it was slightly unusual.
I had the same thought. And we don't have everything here. Obviously, this is a relatively short opinion. And so, we've not seen the full London arbitration claim form and what have you. But there are some parts that are quoted from the arbitration claim, which we're kind of basing that on. But there's a practitioner's point in there, isn't there, around because it's an uncomfortable concept. If you and I've had this thought before. Well, we're in the middle. We're facing a claim coming in. We want to defend that and defend it assertively. We might not have the input from the party below us, so we're going to come up with all the defenses we can. But then at the same time, we're going to turn around and bring a claim down the chain against them and say everything that we opposite to what we've just said against someone else, right? It is an uncomfortable kind of position to be in, but it's done. It's done regularly. 2
weeks ago when we served our claim submissions, we were saying the exact opposite of what we're saying now in a separate reference, but it's just the way that it's done in these back-to-back claims. In order to preserve your position as the middle party, you simply flip the submissions up and down. Now here it's different, critically different, because they weren't truly back-to-back. So they're trying to pass this claim on in a slightly different way.
But I suppose what one point emphasised here, though, is you're right in that it's different. It's not they're not truly back-to-back and they're looking to pass it on. But what is really, and the reason why we're emphasising this right at the outset, is this security action really turns on whether these claims are contingent or not. And actually, how the claim was styled ultimately is what worked against Bunge as the appellant here in respect of part of this overall claim for security. And I thought that was really interesting, that the court looked more at how the claim had been drafted and how it was framed under English law than how it it is as a matter of law, if that makes sense.
I totally agree. It was an interesting opinion in that respect. And it may also help to separate out the two claims. One was for these costs of the settlement with the birth owner, and the other was for the loss of hire throughout that period. And these were the claims that were brought by Tongli. Tongli head owners effectively said to Bunge, "You have to pay us hire for the duration of the time that the vessel was stuck. And on top of that, you also have to pay us presumably under the normal indemnity in a time charter party." The owners here, Tongli, were saying you have to indemnify us for the losses that we suffered in paying off the birth owner. And Bunge's claim down the chain was separated in those two ways as well. The first was, if we had to pay hire for time that we didn't use, then we want to recover that hire from ADM. And secondly, if we have to pay for the birth owner's costs, we want to recover that as well. And therefore, we bring this security action against ADM in America, and I think it was in Delaware. We bring the security action in respect of those claims, and we want them to pay into escrow or give us security in respect of those claims in order for us to lift an attachment on their assets.
For those who know this territory well, we'll be right across what Rule B means. It's a little, catchphrase there that anyone in this space knows what that's about. For those that have dabbled or don't know much about maritime law at all, Rule B is a part of the United States Code, and there's a section there dealing with maritime attachment jurisdiction. In short, you can attach assets of a debtor that you're pursuing and that you have a claim against. Here are a couple of claims. And you attach, arrest, hold those assets as security where in the jurisdiction that they're found within the US, and you secure those assets pending the resolution of an underlying substantive claim. And what's important about that is that the defendant cannot be found within that jurisdiction. So there are a few elements to getting a Rule B attachment. One of them is that the defendant cannot be found. Another one is that there is a valid prima facie maritime claim or admiralty claim. And it's that limb of the Rule B test that we are looking at in detail here. What is a valid, important to emphasize valid in there as well, valid prima facie admiralty claim. There's no doubt that this is an admiralty maritime claim. It's clearly within maritime jurisdiction. We're not dealing with a commodities dispute or something else. We're talking about a time charter party and then a voyage charter party. It's well within maritime jurisdiction. That's not the issue. What we're looking at is whether there's a valid prima facie claim, and the part of that that's being unpacked in this decision is there has the claim crystallized sufficiently? Is the underlying claim possible of adjudication now, not some point in the future, not contingent upon a later event happening before that claim becomes ripe? Is the underlying claim ripe, crystallized? Is it fully formed now such that you can get security in support of that claim? And that's what we're exploring here in quite some detail. And where the court starts is by looking at the heightened pleading standard for Rule B attachments. And unlike normal substantive claims, which is notice pleading, with you've just got to set out the bare facts to kind of make out the claim, in a Rule B attachment proceeding, you have a heightened pleading standard, meaning you've got to give more facts about the nature of the underlying claim, such that you can get the Rule B off the ground. I think it's an interesting point to kind of put an underline on, Calum, because that, I think, guided the court into where it ended up in looking at how the claim was actually pleaded in England.
That's the point as well, is it not, of just US practice in general. I think the pleading standard is slightly less detailed than you would see, I guess, particularly in arbitration pleadings that are over in the United Kingdom or in England. Maybe a little more in line with what you would expect to see in English High Court pleadings, perhaps, where you do set out the facts, but it's not. In my experience, at least, a High Court pleading will be a slightly less, fulsome document than an arbitration pleading, where you're really setting out everything. And I think even less so typically in your first pass US pleadings. So I think that the Rule B standard is almost what you would expect to see as a practitioner in London maritime arbitration, where you have to set out basically have to set out in reasonable detail all the facts and law on which you rely.
Yeah, I agree with that. I tend to think the heightened Rule B standard is probably equivalent to the English court standard in terms of specificity. Maritime claim submissions, as we know them, definitely would get to the Rule B standard, the heightened Rule B pleading standard. I think the US normal complaint, not in this kind of heightened standard, it does not require as much detail as you would see in an English court claim. Anyway, there's margins within that, and some claims are quite detailed, others are not. But anyway, it's I think the point to emphasize here is that is where the court is starting, and so it's actually quite important how the English arbitration claim is drafted out. And we've seen this, and we're a firm that's set up to handle both the English substantive action and also the Rule B attachment proceedings, technically in two different firms, but we're set up in that way. And when we're drafting a Rule B application, we have a lot of consideration around how is this going to be framed in the English arbitration, or how has it been claimed in English arbitration with a view to the Rule B, and getting that, making sure they marry up, and that you're satisfying the requirements on the English side to make out the claim, but you're also thinking about some of the challenges you might face, like this one that we saw on the contingency point on the Rule B side, is quite important.
It really is, and this case just throws a light on it. Maybe helpful to start from the English law position of what are your options if you are a party who is claiming against another party in respect of a loss that you've suffered because of a claim brought by a third party. How do you recover from party B a loss that you're exposed to under a contract with party C, effectively? And the law on that is in a case called Caroline P, a 1985 case, which effectively says you've got three different limbs that it could be. You could be claiming against, when you're passing that claim on, it could be as a breach of contract, it could be as an express indemnity, or it could be as an implied indemnity, or it could be some combination of the three. That's basically how you recover that loss. And the question here is which of those things was being claimed. And it's a reasonably interesting question to answer. And this is where they really looked in detail at how the claim was set out.
As we said at the outset, there were two types of claims that the court looked at. One was the pass-through of this amount that the head owners had paid to the dock owners and other associated costs, which head owners Tongley were claiming against Bunge, and then Bunge in a separate arbitration under the Voyage Charter was looking to claim from ADM. And the other claim was the loss of hire claim, which let's come on to that in a minute. But the first one was this pass-through, if you like, of the settlement and other sums that the head owners had incurred to third parties. And in the claim between Bunge and ADM, and that's what this whole security action was about, Bunge tried to get security from ADM. The question was, what type of claim was that action? And it had been styled as a breach of voyage charter party, and in the alternative, as an implied indemnity claim. So that's Bunge claiming against ADM as an outright breach of contract, or in the alternative as an indemnity. And why that's important is because a breach of contract claim and an indemnity claim are different in their nature. A breach of charter party claim is a direct claim in the sense that you have to make out, you have to get through the Hadley and Baxendale type tests around remoteness and what have you, and foreseeability. But even if some of the damages are contingent, the nature of the claim itself is direct, and it can be adjudicated now. It doesn't require something else to happen before that claim can be adjudicated. The implied indemnity claim, or an indemnity claim on the other hand, that requires some crystallization of the underlying loss for which you're seeking indemnity. So at a minimum, you would need a judgment or an award or some kind of judicial finding or indeed a settlement. That's not the original settlement. That would be a settlement between head owners and Bunge. And there's authority to say you even need to go one step further than that and have payment made against the judgment. We don't need to get into that, but the point for today is that when you're looking at an indemnity claim rather than a breach of contract claim, you need that crystallization of the underlying loss before the indemnity claim can be adjudicated. And so you've got these two different ones, and the court said, you can have them both. They both can exist as alternative claims, but it's really important to kind of unpack that there are two different types of claims there.
Yeah, exactly. And this is just a general principle of English law, is that your cause of action under an indemnity only accrues on payment of the thing that you're seeking an indemnity of. You can't claim a general indemnity under English law without having first made the payment. Now you can claim indemnification as your remedy for a breach of contract claim. That's the distinction here, at least as I understand it, and that's really what the court found here. They said where Bunge is claiming an implied indemnity, it's seeking its claim is premised on an indemnity, and that indemnity, there's no cause of action in respect to that indemnity until Bunge makes payment to head owners for the loss. And as it stands, Bunge is resisting payment, in fact, taking head owners to arbitration to resist payment of that amount. So there's still no cause of action under that indemnity. However, under their contractual claim, which was for breach of safe port warranty, they were entitled to maintain a claim, and they were entitled to say, we have a claim against you which is for a breach of contract, and the damages that we're seeking is indemnification of our losses up the chain.
Yeah, and I totally agree about the position under English law as to when the claim crystallizes. There is what I'm referring to is under US law, there have been some cases in other jurisdictions around whether it's enough to have the underlying judgment or underlying award for the purposes of crystallizing or eliminating the contingency element of an indemnity claim for the purposes of Rule B. I think this case is making it clearer that, or leaning more towards the side that you actually need a fully formed, properly constructed indemnity claim with payment to make that out, assuming you don't also have a breach of contract claim, which the parties did have here. So that's kind of the point I'm making. And as a kind of an aside comment, Calum, that was actually one of the cases that Ed, our partner Ed Floyd, and I worked on many, many years ago, where we were on for ship owners, and we brought a Rule B attachment in the US for security in respect of a letter of indemnity claim. It was a misdelivery. We'd had a sister ship arrested. We'd posted security. We had some losses that we'd paid out in respect of that. And then we went and sought security against the charterers in the US in respect of an indemnity claim, basically. Now, we had other claims a bit like this dressed up in there as well, but it really turned on an indemnity claim. And as it turned out, the matter ended up resolving before the challenge to the Rule B had been decided. And this was in the Second Circuit in New York. But I remember flying over and, watching Ed argue that case. This is when I was just an English solicitor before. This is 14 years ago, before I was a New York attorney. And, we were quite worried about this argument that the claim wasn't properly crystallized because there hadn't been underlying payment. So anyway, I was definitely saying before, I think this is a really important decision actually, for Rule B practitioners. It's something I don't think gets enough consideration at times. So yeah,
it's interesting because it's a very common claim under a charter party to say that you have an implied indemnity or indeed an express indemnity, and it is really interesting for a party sat in the middle relying on that indemnity. There's a slight oddity here in that the indemnity that Bunge are seeking to rely on is under a voyage charter party, and I think they'll struggle in the English proceedings to persuade a tribunal that there's an implied indemnity, or the normal time charter party implied indemnity extends to a voyage charter party. I'll be interested to see if we hear any further on that one, because currently the currently settled law, as I understand it, is that implied indemnity does not extend to a disponent owner under a voyage charter, only under a time charter. So there's an interesting English point of law there. But that said, it's very common, particularly in a time charter party context, to be looking for a recovery of some losses under an implied indemnity. So this is not a nuance that I picked up in Rule B claims. Obviously, you and Ed have from some time ago, but it's a very interesting point to me.
Well, the implied indemnity for following employment orders, will that fall into this category though? Is it because I don't know, does that have the same contingency dimension that we're looking at here when it's being passed through?
At a surface level, I would have thought that is effectively the indemnity that Bunge were alleging here, is that they have some kind of implied indemnity that if they follow the voyage required under the voyage charter, they're indemnified for the consequences of it.
Yeah, I'm thinking more in a head charter context, in the time charter party, where you have an implied indemnity for following employment orders, but the underlying loss is that, well, I suppose if it's continued to another third party, then you get the indemnity. But if it's direct losses of the head owner, I don't know. Anyway, it really does. It does create some interesting thoughts around this, and when challenging Rule Bs, whether the claim has actually been properly crystallized.
Kind of cutting to the end, the court went split direction on the two different claims, the two different damages that were claimed here. The first being these losses for or the indemnity, if you like, where there was a pleading of general indemnification under an implied indemnity, but there was also this pleading of an indemnification by way of damages for a breach of a safe port warranty. And the court said, because you have that contractual breach claim, you get home on it. The second claim, this was the claim for the repayment of the hire that Bunge said they didn't owe in the head reference. This is where the drafting really kind of caught Bunge out, if you like. They'd argued very firmly that their position was that no hire was payable up the chain, and that anything in the subcharter, they'd been pretty clear, was contingent on a finding that they would disagree with, that they were obliged to pay hire up the chain. And it was only in those circumstances that they would want the money back from ADM. And the effect of that was at least for the US court, the effect of that was to say, well, actually, right now you don't have a claim because your claim is expressly contingent on something happening in the head reference, and that's not happened yet. So we can't we can't consider this to be a valid prima facie claim because there is no claim until the contingency is lifted.
I know it's almost ironic because I would have thought that claim is less contingent than the other one that survived, save for the way that it was drafted. Although one of them, the loss seems closer, if you like, to Bunge than the other one that had been a settlement of a third party claim by head owners. Yeah, you're right. It's just I think the drafting here caught them out. Now they managed to still get $7 million or so in security, and it was only a $480,000 claim that they failed on. So in the grand scheme of things, they're probably pretty comfortable with that, especially considering that it's ADM on the other side.
The liability up the chain seemed to only be $3.5 million anyway, or $3.25 million. So they seem pretty well secured they seem pretty well secured anyway. But I don't know who knows? Maybe ADM will still argue that the security doesn't extend to the higher piece of the claim.
Well, that's an interesting point. I had that thought too. Is if you have a situation like a different kind of scenario, if you have a claim where, let's take the $7 million one, where it can be put as a breach of contract or it can be put as an indemnity claim, but you only ultimately succeed on the indemnity claim and not on the breach of contract claim. I don't know. I'm trying to think of a fact pattern that would throw to that.
Yeah, I think that makes sense. If they say there was no breach of the safe port warranty because the port was safe in that you could, without the instance of an extraordinary event, arrive at it, do your cargo business, and leave, or whatever the test is under English law. But on this occasion, there was an event that meant that charterers were liable under an implied indemnity to the extent one exists under a voyage charter party. Then they would get home on the implied indemnity, but not on the safe port warranty claim.
Yeah. So what I'm posing is, could you try and offer security, or say, okay, we're going to accept security only with respect to the breach of contract claim, so that the security will pay out for the breach of contract claim count or cause of action, but it won't for the other, and actually have it narrowly drawn in that way.
I can't see why you wouldn't. And if you did, I suppose the question really is, if you put it that way, then would the court say, would the court release any attachment on the basis that security had been provided, so there was no need for the attachment anymore?
Yeah, look, it's a good case, this one, and I always like those cases that make you look again at things you think you know so well, you've dealt with many times before, and say, oh, hang on, what about this angle, or what about that angle, or maybe we can look a bit more at this, or look a bit more at that. This
one really made me think along those exact lines. I thought that I knew Rule B in the context of your typical maritime arbitration claims pretty well, and I've come away from this case thinking, well, firstly knowing it a bit better, but secondly thinking that there's clearly still more to know. Well, thank you everyone for listening in. We hope you've enjoyed this and gotten something out of the discussion. If you want to talk more about Rule B and how it interacts with English substantive law, there's a lot involved in this. It's an area we really do, and I'm not just saying this for the sake of it, we really do look closely at these things and these types of claims. We enjoy them. We're structured to handle them. And as you can see, the interplay between the English law and the US procedural law is super important in these types of actions. Well, yeah, thank you all for listening in. A very enjoyable podcasting session, Luke, and look forward to the next one. Until next time, take care, everyone.